navigating Australian employment law, rights and responsibilities for employees and employees. Now, at Lawpath, we are proud to be Australia's largest online legal and accounting platform. Over the past 10 years, we've helped more than 600,000 businesses get set up, stay compliant, and grow. In fact, we've saved small businesses over 500 million in legal fees by making legal and accounting services affordable, subscription-based, and easy to access. So instead of unpredictable hourly fees that you're used to from maybe your accountants or lawyers, our members get unlimited access to expert support, documents, and tools whenever they need with the click of a button, all under one roof. An umbrella company, excuse the pun. Now, why today's webinar matters. When you hire staff for the first time, you're not just a business owner anymore. You're also an employer. And that role brings with it a whole new set of legal responsibilities. Employment agreements aren't just paperwork, they are the foundation of your workplace relationships. Be all end all. If they're not done properly, you could be facing things such as fair work penalties of up to $66,000 per breach, unfair dismissal claims from unclear termination clauses. That's a big one we're seeing a lot with a lot of our clientele coming in. IP ownership disputes when staff create work for your business, but you haven't outlined within a document whether or not it belongs to you or whomever's created it. Confidentiality breaches, another big one. That puts sensitive data from your business at risk, essentially. Worker misclassification issues leading to years of back pay and liabilities, another big issue we see a lot of. So that's why having an experienced employment lawyer review or draft your contracts is important. At Lawpath, our lawyers don't just tick compliance boxes, they structure agreements to protect your long-term business interests. It's a guarantee. How Lawpath can help. So we've built our platforms so that small businesses can get the same protection as large companies, but at a fraction of the cost. So our subscription plans give you unlimited legal consultations, on-call contract reviews, access to over 500 plus legal and HR documents, employment, HR, debt recovery, intellectual property, non-disclosures, commercial related, it's all there. And you also get year-round support for a single fixed cost. Now, I'm more than happy to go into detail with this later on. So yeah, if you are eager to get some support, fear not, I will go through that later on. And I will also be offering people to send me their information later on so I can give you a call. If the business is new or if you're moving it into a transitional phase where you are taking on employees because it's expansion, that's wonderful. We're here to support you and I can take you through some details in greater detail for you later. Ugh. Now, who is our speaker today? Jess Hui. I'm delighted to introduce Jess. This is her first time coming on to speak on a webinar, so please be kind. Jess is a practicing solicitor admitted to the Supreme Court of New South Wales and also a public notary. She has over 20 years of experience working with leading law firms across the US, UK, and Australia, as well as in-house roles at brands like Prada and Hasbro, which I only learned today. So that's really cool. I have to pick her brain about that later on. Her deep expertise span corporate and employment law, including drafting employment contracts, contractor agreements, and workplace policies, advising on HR and compliance and disputes, representing clients in unfair dismissals and general protection claims. In fact, Jess recently represented an applicant in a Fair Work Commission case, Raju v. AgriPower, and she successfully won after a full day's hearing. So really, really excited to have Jess on board, and I hope you guys get some great insight and wisdom from her. Now, what will Jess be covering today? Employer obligations under the Fair Work Act, employee rights and entitlements under the National Employment Standards, NES, how to draft strong, compliant employee contracts, common pitfalls small businesses face in HR compliance, and practical steps to keep your business compliant and protected. So by the end, hopefully you'll walk away with a clear roadmap to ensure your agreements don't just keep you compliant, but also help you build trust with your team and safeguard your business. Now, if you guys do have questions, which I hope you do, we will have a Q&A at the end. So seeing as this is Jess's first webinar, we want to able to keep a bit of a flow going. So if you can just save those questions to the end, chuck it in the Q&A or the chat. I promise we will do our best to get through to those as well. And if you have anything else related to a legal matter within the realm of what we're discussing that Jess may not necessarily mention, feel free to chuck it in there as well. We might be able to go ahead and address that for you as well. But without further ado, I will go ahead and pass it over to Jess. And once again, thank you all for sitting with us today.
Thank you, Joe, for the introduction. Can you all hear me?
Yep, loud and clear.
Yep. So let's talk about some legal obligations. Start immediately when you hire an employee. So the obligation starts the moment you hire, even for a casual employee. And these aren't optional and they apply from the day one. So first of all, you need to give all the employees a fair work information statement. And in the case of a casual worker, you have to give the casual work information statement. So you have to give to every one of them, and unless they are contractors, okay. So the information statement will outline their rights at work under the Fair Work Act. And as an employer, you need to be compliant with employment contracts. All the employment contracts must outline the roles the employee is performing, their duties, the pay rate, the classification, and conditions in line with applicable awards and legislation. And you also need to get all the employees to sign a superannuation standard choice form. You have to allow them to nominate their preferred super fund if they do have one. Otherwise, if they don't have one, they can use your default super fund. The super funds chosen by the company. And you also need to have your employees to declare their tax file number, which is commonly known as the TFN. And the TFN is used to set up PAYG tax withholding and reporting to the ATO. If you fail to have the employees do the declaration and provide the super funds that they prefer and sign the employment contract, or if you fail to provide all these fair work information statement to the employees, then there's a possibility that it may lead to some fair work compliance issues and penalties. So what do you need to do in order to register as an employer? You need to register for PAYG withholding with the ATO. This allows you to withhold tax from your employees' wages and remit it to the ATO. And you need to set up superannuation payments. You need to use a super clearing house, like the ATO's free small business superannuation clearing house, to make contributions at least quarterly. You can do it more frequently, like fortnightly or weekly, if you wish to, but at least quarterly. And then you also need to store employees' records securely. This includes their contracts, the TFN declarations, the superannuation details, and you also need to keep these records private, secure, and accessible for audit purposes. And for audit purposes, you need to keep all these documents generally for at least 7 years. So apart from the initial obligations, you also have some ongoing obligations as an employer. So you need to pay the correct wages, and in some instances, when a modern award is applicable, then you need to pay the award wages. So you need to ensure the employees are classified correctly and they are paid in accordance with their applicable modern award. Or in some instance, for example, some big corporations, they will have an enterprise agreement, for example, like Qantas, Telstra. So in those cases, you also need to comply with the enterprises agreements terms and conditions. And These would include overtime payment, penalty rates, and allowances that you need to pay to your employees. You also have to provide leave entitlements to your employees, and they will include annual leave, sick leave, carers leave, non-service leave, and unpaid parental leave must be checked. And these leave will be accrued and they will be offered in line with the National Employment Standards, which we call NES, or applicable modern awards or the enterprise agreement. You also need to provide safe working conditions to the employees, and they include a safe workplace under state and federal work health and safety laws. And this includes assessing risk, providing safety equipment, and ensuring staff training is provided from time to time. And you also need to maintain all accurate records, whether they regard to the employee's leaves or the employee's pay and their work safety conditions for at least 7 years. Okay. And if you have a probation period for your employee, it's commonly 3 to 6 months. Why we put it, why is commonly 3 to 6 months? We'll explain it later. But usually, you should state it clearly in your employment contract. The terms of termination during probation period will also need to be mentioned in your contract, and any conditions for review or extension of probation period. So normally probation period is a fixed period. In rare cases, it will get extended. Okay, and you must also follow correct steps for termination, including written notice and performance management, even during probation period. And probationary employees are still entitled to super, pay slips, leave accruals, and protection from unlawful termination. So bear in mind that unlawful termination here is different from unfair dismissal. So if you look at the notes I put it here, for an unfair dismissal under the Fair Work Act and under Part 3.2 of the Fair Work Act 2009, an employee must be employed for at least 6 months with a non-small business employer, or 12 months with a small business employer in order to be eligible for making the claim. And small business employer is defined as an employer having 15 employees or more, or less, sorry. So employer setup checklist. So when you set up your business and you consider hiring any employee, you need to have an Australian business number, which we call ABN. It is required to legally operate and hire staff. And you also need to have PAYG registration. So you need to register with the ATO to withhold and report employee tax. You also need to have the TFN declarations. So you need to collect and submit all the tax file numbers, declarations from the employees. And you also need to set up your superannuation contribution. So set up a super fund and clearinghouse for employee contributions. And you need to provide the Fair Work information sheet, including the cash employment information sheet, and to all the new employees. And you need to sign an employment contract with each of the employees, which should be in compliance written agreement outlining all the key terms. And you also need to purchase insurance policies, including the workers' compensation. And so the workers' compensation is mandatory in all states and territories to cover employee injuries. So what are the employees' rights and entitlements? Most of the employees' entitlements are outlined in the National Employment Standards. So what is it? So the National Employment Standards are the 12 minimum standards of employment that apply to all employees, covering all the employees' national workplace relations and their workplace rights. So these standards override any lesser provisions in employment contracts. Let's look at the national employment standards. The key entitlements include, number one, the maximum weekly hours. So you need to ensure that if you are hiring a full-time employee, they work 30 hours per week. So occasionally you can have them work reasonable hours exceeding the 38 hours, but it has to be reasonable in a case-by-case scenario. And flexible work request. So if there is an employee requesting for flexible work, they need to make the request, but it's only available to them after 12 months of service for the same employer. If they work for a different employer, that doesn't apply. Casual employment. So casual employment, if you're hiring a casual employee, the eligible casual employee can request permanency after 6 months or 12 months of service for the same employer. And employees would have their parental leave and related entitlements. So basically, they have up to 12 months unpaid parental leave and with potential extensions if they do require extended leave. They usually have 4 weeks annual leave for the full-time employees, and the annual leave will be proratably calculated for part-time employees. And personal and carers leave is also available for part-time and full-time employees. And so they will have 10 days paid personal and carers leave plus 2 days of unpaid personal and carers leave where applicable. And they will also get 2 days of paid compassionate leave each time when the criteria is met. And also they will have up to 10 days of paid family and domestic violence leave each year if they are eligible. Full-time and part-time employees will also enjoy community service leave. Community service leave is used for employees for attending jury duty or emergency roles. So there's no limit on the amount of leave that they can take. It would depending on the emergency matter and also depending on the number of days required for the jury service. But they need to provide all the supporting documents to the employer if they want to attend those emergency roles or jury duty. Long service leave is different from state to state. So you have to check every state's laws and also applicable awards for the long service leave. Public holidays is also different from state to state. So check your state's public holidays, and they need to be, if you're requiring an employee to work on a public holiday, you need to pay them for the public holiday pay, and according to the applicable award, and it will be paid if the employee would normally work on that public holiday. And you also need to provide superannuation contributions, and the current employer's superannuation contribution is at the rate of 12% of an employee's ordinary time earnings. This percentage may change from time to time, depending on the government's policy, but at the moment it's 12%, and in the coming 2 years is set to be 12% unless there's any change from the government's policy. So when you want to terminate an employee's employment, you need to give them notice, and the notice period will depending on the length of service. And if there is a genuine redundancy, then you can make the employee redundant, but bear in mind that you may need to pay redundancy pay. And as said before, you need to provide Fair Work Information Statement and the Casual Employment Information Statement. So Fair Work Information Statement is provided at the beginning of the employment to all the employees, but Casual Employment Information Statement must also be provided from time to time. Normally, it will be on each anniversary of the commencement date of the casual employee starting the employment. So what are the types of the employees? So we've got full-time employment. usually working 38 hours per week, entitled to full NES benefit. And we also have part-time employees. They work regular hours, less than 38 hours per week. They are receiving entitlements on a pro rata basis. And we also have casual employees. And these casual employees, they do not have guarantee for working hours. So they are not guaranteed to have a particular hours of work. And they are required on an on-demand basis. And they usually enjoy higher hourly rate. They get paid higher hourly rate, including the casual loading. Typically, is 25% to offset the lack of leave entitlements. And then we also have a fixed-term employment for fixed-term employees. So those fixed-term employees, they are basically working under a contract for a specific period of time or a specific project. And they do have same entitlements as full-time and part-time employees, but the contract is usually short. It's usually 1 to 2 years. So the modern awards apply to some industry and to some employees. They do not apply to every employee or every industry. So there are legal documents that set minimum terms and conditions for specific industries and occupations. They apply on top of the NES and cannot be contracted out unless in special situations like when you are able to prove that you're paying them. For example, when you prove that you can pay the employees better off overall, then you in that situation you may not need to comply with the award payment. Each award may include a minimum pay rate based on classification level and age. As I said, unless you can prove that you're paying them better off. Otherwise, you have to comply with this minimum pay rate. And there are penalty rate and overtime payments that you need to comply with. For example, evening payment, weekend payment, and public holiday payment. Allowances. So there are allowances that you may need to pay to your employees if they are applicable. So, for example, uniform allowances, travel allowances, and special duties allowance, such as first aid duties, if you require them to perform the first aid duty. If your employees are on roster or then they might have some minimum break during their roster period, and there is a maximum shift length and the rest between shifts. So usually there will be a maximum shift of about 2 weeks, depending on the details of your roster. Classifications. So make sure that you classify your employees correctly under each award. Some awards will mention that different level of employees will be under different levels, and they have different levels of pay scale. So make sure that you determine their level of skills and their duties correctly in order to determine how much you're paying them. So what are the tips for complying with these modern awards requirements? You can use the Fair Work Award Finder to check which award applies to your employee's role and to your business. What are the leave entitlements that we're talking about that you need to give to that your employees enjoy working as a full-time or part-time or other types of employment? So there are core parts of national employment standards that set out the varying the leave entitlements depending on the type of employment. So full-time and part-time employees, they have 4 weeks of annual leave. It's paid annual leave per year, and then they accrued progressively based on hours worked. And additional leave may apply to certain shift workers. And they also have 10 days of paid personal leave, also known as the sick leave, which accrues progressively, includes carers leave for supporting immediate family and household members. You also get unpaid parental leave if the employee is pregnant or adopting a baby. So it's got up to the unpaid leave is up to 12 months, and it's only for eligible employees only. So for eligible employees after the birth or adoption of a child, and within the option to request an extension of up to 12 months more. And as we mentioned before, there is compassionate leave, 2 days per occasion for the death or life-threatening illness of a close relative, usually someone from the immediate family. And there's also family and domestic violence leave, 10 days paid leave each year. You can request for further leave if the circumstances provide, and it's on case-by-case basis. Community service leave, there's no limit on the amount of leave, depending on the requirement of the jury service or the emergency role that you are attending. Long service leave. So as I said, the entitlement to long service leave, it varies by state and territory. In New South Wales, long service leave typically applies after 10 years of continuous service with 2 months leave accrued. And in some other states, it might be 7 years or any other number of years. So before you check on the employee's leave entitlement, you need to check which states they are performing the duties. If your company has several presence in different states, then you need to check where the employee is providing the service from. And some awards and agreements may provide for earlier access. For example, after 7 years in New South Wales, then you can have some partial access to your long service leave. A portable long service leave scheme applies in some industries, such as construction or community services. This is for employers in a particular industry, for example, the construction, because the construction work are different from other services. A lot of employees in construction industry, they work from one construction site to another. So the law allows them to carry on their long service leave from one employer to another employer under a special portable long service leave scheme. So bear in mind, always check state legislation or applicable award for the exact long service leave provisions. We've got a table here quickly to give you some idea of the difference between the various key leaves. For example, the annual leave between full-time employee, part-time employee, and casual employee. Basically, casual employee doesn't have any leave. They don't have sick leave or carers leave, but they would still enjoy the compassionate leave, parental leave, and the long service leave if they are eligible. And as a casual employee, they don't have the public holiday pay because if they are rostered to unless they are rostered on a roster plan to perform duties in like a continuous roster period of time, then otherwise they won't be entitled to public holidays pay. Bear in mind that casual employee will have a loading of 25% to compensate for the lack of paid leave. So let's talk about the employment contracts, the pay and the leave. For employment contract, although oral contract is still valid, but I recommend that each employee should have a written employment contract, and so that it will avoid any dispute or any confusion over the terms of the employment. The 6 key things that you need to include in your employment contract will be the following: job duties and job title. So you need to clearly outline responsibilities and the expectations for the role to avoid ambiguity. For example, if you require them to supervise any employee, any junior employee, then you need to specify that in the employment contract. Otherwise, there will be disputes over whether they have that duty to supervise any junior employee. And you need to mention their type of employment, whether it's a full-time, it's part-time, or a casual employment. defining the nature of employment to ensure that the correct entitlements is very important. And if there is any award applicable, then you also need to mention it to avoid any ambiguity. You also need to state the base rate or hourly rate that you're paying them. Whether if you are offering a salary package, you need to break it down into base rate and any other commission payment or bonus payment to ensure that the pay is clear. And you also need to ensure that superannuation is paid to the employee in compliance with the current legal minimums. At the moment, it's 12%. And entitlements. So you don't need to if you just want to follow the national employment standards and there's no award applicable, then you can just say the employee will be we have the leave entitlement following the national employment standards. You don't need to copy and paste all the rules from the national employment standard to your employment contract, but it would be good to have some summarized point or some basic information there in your employment contract, so that the employee at least know how many leave they would have under each category. Sorry. And you also need to insert a clause of confidentiality into your contract, because your trade secret and all the information that the employee would be using or have access to during the course of their employment would be confidential information of the employer, and you want to maintain their confidentiality, and even after the employee leaves the company or their employment has been terminated. So a clause about confidentiality is very important. And also IP rights is also important to you, to the company. So in order to protect your business by any employee accessing the intellectual property of the company, you need to state in your employment contract that the ownership of all these intellectual property are owned by the company, and anything that they create during their course of employment would also be owned by the company. And so they cannot misappropriate those intellectual property. And also you need to also specify notice period for termination, and what are the conditions for termination, whether the employee can terminate their agreement, and how many days of notice they need to give to the company in order to resign or to terminate their employment, and the grounds of termination if available to the company if the company wants to terminate an employee's employment. For example, summary dismissal or any other grounds, and also the termination during probation period. Usually people would choose to have either 1 week for the probation period, or a shorter period of time if it is agreed between the employer and the employee. There are some common contract mistakes that employers usually encounter, and for example, they might be coming from the US or UK, and they might be using a US or UK template that were made available to them. And however, bear in mind that Australians' employment law is different from those of the UK or US, and we don't usually include those US or UK templates usually don't include the key Australian legal requirements, such as the leave entitlements, the NES compliance, or the superannuation requirements. And the templates may not include modern awards requirements as well, because in Australia we have the Australian modern awards requirements, and the awards they set some pay or allowances or risk requirements if a modern award is applicable, then you need to state those in your contract, and these are usually missed in the US or UK template. Also, in the US-centric terms, they always use actual employment, but we don't have that concept in Australia. So bear in mind that don't use those kind of US term in your employment contract. If you fail to update your employment contract to reflect the changes in job duties, the pay, the classification, then there is a risk that you will be non-compliant as an employer under the Fair Work Act. So bear in mind that if there is any update in the salary or the job duties, for example, an employee is moving from one position to another, or from one department to another, or there's a increase in their salary due to the job movement, then you need to update your contract. So pay slips and record keeping. You need to provide pay slips 1 working day of paying an employee. So if the employee got paid normally on a Thursday, you need to provide them with a pay slip at least on Friday. And the pay slip will have to include the employer and the employee's name, the pay period, and the date of payment. Gross and net pay of that particular payment, hours worked and the rate of pay, superannuation contributions, and any deductions. And for example, the PAYG withholding. And you also need to keep all the records of employment, including the employment contract and including all the pay slips for a mandatory period of 7 years. And they must include the wage and the tax records, the timesheets or rosters, and the leave balances and accruals, any superannuation contributions, and copies of contracts and variations, as we mentioned before. If you fail to comply with all these requirements, then penalties may apply, and the ATO may require an audit on your compliance. Your superannuation obligations is so the current superannuation rate that is required from an employer is 12% as of 1st of July 2025. As I mentioned, the government doesn't have immediate plan to change that rate in the coming 2 years, but that would depend on the government policy. Contributions must be paid at least quarterly. It can be done monthly or with each pay cycle. If your pay cycle is fortnight, then you can pay fortnightly. Employers must allow employees to nominate their preferred superannuation fund, and then the employer will also need to use a super clearinghouse for processing. It will they will have to reflect the rate of the superannuation in the employment contract. If you miss any superannuation payment, it will result in some super guarantee charge, and which will include interest and administration penalties. Leave management. So bear in mind that there are various leave applicable to an employee. So the best way to handle it would be to implement a leave management system or payroll software that checks accruals and requests for leave from the employees. So you should encourage your employees to regularly check their leave balances and apply with reasonable notice. And you also need to maintain a clear internal policies outlining how to request leave. Usually leave has to be requested in writing in order to avoid any disputes. I noticed some employers would allow employees to request leave orally, but then a lot of time it creates confusion and it creates disputes over whether it is authorized leave or unauthorized leave. So my suggestion is always require your employee to request leave in writing. And you have to document all the approvals from the company, and also ask employees to provide evidence of their leave. For example, if it is a sick leave, you need to ask them to ask them to provide their medical certificate. As I said, always confirm leave approvals in writing as well, to avoid confusion or disputes later. What are the common compliance pitfalls? So I list out some common compliance mistakes here. Misclassification of employees. A lot of time, especially when a modern award applies to a company or to an employee, there is a misclassification of employee type or employee level. So sometimes an employer may mistreat their employee as a part-time employee when they're not, or treating them as regular casual staff, or as an independent contractor when they are actually an employee. So check your employee status and the requirements under each award to correctly classify each employee and their level under the applicable award. Also, a lot of time there are incorrect pay rates identified by employers. So pay rates has to be either in line with the National Employment Standards, the minimum wage, or in line with the minimum wage set out in each applicable award. And also bear in mind that there are penalty rates and overtime rates. If you're not paying additional penalty or overtime rates, you have to work out a better off overall rate that you want to pay to your employees. And also a lot of time employers fail to keep all the documentation and to give the Fair Information Statement or the casual employment information statement to the employee as required by law. And so keep in mind that these information statements are important. You need to give to the employees either at the beginning of the employment or for casual employees each anniversary of their employment. And you also need to keep all the records. Missing any pay slips, timesheets, or super reports or tax declarations may be problematic. So bear in mind that you need to keep all these records for at least 7 years, because ATO might from time to time do some audits on the employment status of each employee. So keep all those records as you're required to. If you miss any superannuation payments, then you need to keep up with the payments regularly. Otherwise, you will incur super guarantee charge and relevant penalties and interest penalties. So what are the consequences if you get it wrong? There will be a Fair Work audit and investigations. And for the breaches of breaching the Fair Work Act or the National Employment Standards. And as I said, ATO might also do some audit on your employment status. And there may be some back pay orders. So you might be asked to back pay all the underpayments that you are supposed to pay to your employees. And so in order to avoid reputational damage, I would recommend you to constantly review your employment with your employees and constantly check whether you have all those records and whether you are paying all the necessary wages and comply with all the superannuation contributions. Because if you do anything non-compliant, then not only the damage of the company's reputation will be damaged, you will also lose the staff trust and it will affect the morale of the staff. So ignorance of the law is not a defense, because as an employer, you are supposed to know the employment law, and if you don't know, you're required to seek professional assistance to help you to get to know the employment law. How do you stay on track with all these employment laws and the updates in law? You can use HR or payroll software to help you to receive some compliance alerts and to do some automated updates. You can also do regular contract review. You can do it by yourself or engage a lawyer to do regular contract reviews for you, at least annually or after any role or pay has been changed. And also, you can stay across legal updates by subscribing to Fair Work some Fair Work newsletters or publications and ATO updates. You can also do some training and checklists. So in order to equip your managers with tools to spot compliance issues and allow your directors to do all the checkings and pick and engage any necessary professionals to give any necessary trainings to the managers. You can also outsource to advisors. So use employment lawyers or HR experts for complex cases, for example, in the fair versus unfair dismissal cases. So what are the compliance health checklists? Fair Work information, including the casual work, casual employment information statements. So you need to provide all these information sheets to the new employees, and because they are mandatory on the commencement, and in the case of casual employee, on each anniversary of their commencement date, and keep accrual, keep all the accurate records of the employees, including their employment contracts, their wage information, any updates on their wage, any leave application, leave approval, and any superannuation contribution, including the superannuation statement. And then pay slips, keep all the pay slips, and also deliver the pay slip to the employees on time. And if anything, any details in the pay slip is wrong, correct them on a timely basis. And also do your ATO reporting, ensure that single touch payroll is compliant, and you have all the payments uploaded on time. Fair Work Ombudsman. So Fair Work Ombudsman provides a award finder, and there's a calculator to help you to find out how much you need to pay your employee. And there are some template documents there available on the Fair Work Ombudsman's website, which you can use if you need to. And also, you can also use Lawpath legal plans to get in touch with lawyers at Lawpath. If you are in our legal consultation plan, we can answer any employment-related issues or any other legal issues that you may have, and we can also help you to review your employment contract. Leave calculators, as I said, there's a leave calculator available by the Fair Work Ombudsman, and also other leave calculators available on the internet. So find the best one, find the best calculator that you find suitable, and do your own calculation. And as I said, you need to, if you're hiring a part-time employee, you need to do the pro rata calculation, and you should do all the long service leave tracking. And if you are a small business, if you want to use the ATO Small Business Super Clearinghouse, then you can visit the ATO's website. It is free and it's easy to use. ATO will also keep records, and so there's the ATO record keeping toolkits. You can follow that as well. So final takeaways. We don't have much time, so I'll quickly go over this. So know your employer obligations. every business with employees must comply with the minimum standards, including the NES, the Fair Work and the awards, and avoids the set the set contracts. Each role is different, and each employee have some employee specific pay scale and duties. So do not use the same template for each employee. You need to customize each employee's employment contract, and you need to review them from time to time, and also keep documentations in your records for at least 7 years, and including all the supporting documents. For example, the employee's request for leave, and also your approval for leave. And also, if you have any question, do seek professional help from your lawyers or HR experts. All right, I'll now hand over to Joe to discuss further on how Lawpath can help you.
Thank you so much, Jess. All right, how's everyone doing? If you are looking to get an employee for the first time, it can be very intimidating, as you can see from all the information that Jess has provided. I'm not a lawyer or an accountant. I'm one of the consultants over here at Lawpath, and so it's my duty to reach out and communicate with people who have come by. And a lot of the time, people are hiring employees for the first time because, as you all know, we have the free document feature where you can come by, and it's a good opportunity for us to kind of reach out and get an idea of, I guess, how wet behind the ears some people are. And not just employee agreements, but a lot of other documents for new businesses. It's always a little bit of naivety, which is totally fine. I have the greatest of respect for anyone who's going to be a business owner and entrepreneur, because there's just so many hoops you have to jump through, and it's it is extremely intimidating. So when I see people coming by and then realizing just everything you need to know about being not only a business owner but also an employer, it can be rather intimidating. So I don't envy you guys, but if the business that you've committed to is what your heart desires, and you know that if you tie up the laces and get into it, then you will succeed, then I have no doubt that is the outcome. I've been here for a long time, and I've found those who I touch base with over a period of time, it's the ones who just roll with the punches, and who actually, they have to love what they're doing to want to stay in there and bite the bullet with a lot of these hard decisions. So if that's what you feel like, where you're at with your business, and you are ready to take the plunge and take on more responsibility by having employees, then we're here to support you 100%. So Lawpath isn't essentially a platform. We like to treat it as a peace of mind, as cliche as that might sound. Most small businesses think of lawyers and accountants as big hourly fees, unpredictable bills and stress. Usually a single contract review within Australia can cost you upwards to $600, and you are getting charged within 6-minute increments from most lawyers in Australia. A fair work slip, a slip up can, obviously mean tens of thousands in penalties, as we've mentioned, and ongoing accounting advice, often out of reach when it's too late. We've kind of flipped the model with our services. So instead of hourly rates, Lawpath works kind of like a Netflix or a Xero subscription. So you pay, and then you get unlimited access to our lawyers and accountants. What it usually looks like is that you would pick a lawyer or an accountant from our team. We're all Australian based. We only deal with Australian-based law. Unfortunately, if you're in New Zealand or elsewhere, we can't assist you. But if you come on and you just want to have someone you can speak to day in and day out, at the drop of a hat, so that you'll never have any ridiculous 4 or 5 day waiting periods at Lawpath. You pick someone from our team that you like, you have an initial consultation with them. If you're happy with them, they will be your ongoing lawyer and accountant, so you don't have to explain yourself to someone new each time. And then you can just dive straight into whatever it is you need. So if it's employee agreements, if it's branching out of state, if it's non-disclosures, if it's taking on a new shareholder or transitioning from sole trader to company, whatever it is, you can get all this advice and assistance and support through the legal advice plan. You can also get your hands on our entire document library. where you can build off templates. So what I've been advised on is that most lawyers are usually using templates as well. I've heard that most lawyers aren't necessarily building documents from scratch for you. So you might be paying a lawyer $600 to $800 per hour for them to basically create a document for you that they're building off a template as well. So what we do here at Lawpath is we give you the pre-written template. You can go through it, create it on your own, and then have one of our lawyers review it to make sure that you're crossing the T's and dotting the I's. Or if you get the contract and you go, I have no idea what I'm looking at, you can just hop on a call and have the lawyer work through the contract with you. So it's not just us ticking the boxes for you, it's also an educational piece. We want you, by the end of your time with Lawpath, to be able to identify when changes to legislation are involved, what specific clauses within each contract means, and if there are changes to them over the period of time, you understand what the terminology means. So it's guidance, support, but also education as well. So the same rule applies with our accounting advice plan. If you guys are taking on employees for the first time, payroll, how do you pay them? When do you pay them? What's fair? Do you want to also pay yourselves? All the stuff you can cover in the accounting advice plan as well. Unlimited 30-minute calls, much like the legal advice plan, every day, Monday to Friday, whenever you want. On these calls with the accounting advice plan, we can teach you how to organize your payroll and bookkeeping through Xero or MyOb, these really amazing new online accounting software systems. We can show you how to pay yourself as a company owner or a sole trader. We can show you strategies in which you can reduce the amount of taxes that you're paying on each service, but we can also show you how to build strong tax strategies, especially built around having employees for the first time as well. So our legal advice plan is usually $1,668. But because you have attended this webinar, you are entitled to a discount, which is 20% off. So you can have unlimited legal calls for an entire year with someone like Jess for only $1,334. If you do have your Lawpath profile open in front of you now, you can just go ahead and click on products and pricing, click on the legal advice plan. Where it says add a coupon code, it's capital LAP WEB, LAP Web 20, and that will also automatically give you a discount there. Look, I could rave on, but for those of you who are new, I will be sending out an email with a little bit more information on what we provide. But also, if anyone is interested in just having a chat with me after this, just around what your future plans are for your business, where you want to go, but also if you're interested in knowing a little bit more about our offers, the deeper, more thorough conversation around our offers, not just the surface stuff, you can just go ahead and chuck yes into the chat, and I'll be more than happy to reach out to you and just be a shoulder to cry on and offer as much advice as possible to see where you're at the moment. And if it's a case of hiring employees later on, or you need something else, then naturally I can kind of give you that information so you can, I guess, have more clarity. But without further ado, we'll go ahead and get into the topic of the Q&A and the questions. Now, we do have some questions, Jess, in the Q&A section, but before we jump into that, we'll go ahead and just go through the list of questions that you guys threw in the chat, because there's been so much communication. We've been documenting, so we didn't want to lose anyone. Yeah, so what I'll do, Jess, is I'll just go ahead and read out some of these questions. If you want to answer them piece by piece, that'll be cool.
Sure, no problem.
All right, so I didn't put down the name, so if I didn't take your name down when you asked the question, I apologize. But if you just want to chuck in a thank you or something, that's fine. So do the super standard choice form and tax file number declaration need to be the standard choice form, or can they be in different format as long as the same formation options are given?
Well, it has to be the form that is the standard form. So there is standard form that you can download from the internet. It is available at the ATO's website, I believe. So have a look at that form and use that form. Do not use any other form.
Oh, forgive me. Sorry, I was on mute. Thank you, Jess. Is community service leave paid leave or unpaid leave?
So community services leave is paid leave, as I said, they are given to employees who are attending any jury duties or any specific roles required. So they are not like so it has to be supported by documents. So if they are asked to attend as in a jury, then there will be usually a letter from the government, from the Department of Justice, and they will have to present that letter to the employer and ask for the leave. And the leave period would usually be specified in the letter.
Brilliant. Fixed term employees. How many times can someone be employed on a fixed term, for example, to run a particular program? Is it possible to operate with people as contractors instead?
So if you're hiring fixed term employee to run a project, then it depends on the project. If the project is a 2-year project, then you hire the employee for a 2-year period. Depending on the project, so it can be extendable depending on the project. But if you keep extending, there might be some suspicion on whether whether the project is actually a termed project, or you're trying to break it into different terms in order to avoid hiring an employee for permanent basis. So as I said, fixed term employees has to be a short period of term, and usually it is 1 to 3 years. Anything beyond 3 years would be too long, and anything within 1 to 3 years is a more reasonable period.
Perfect. Thank you. Are contracted employees entitled to paid leave? This is one we get a lot.
So I'm not quite sure whether you mentioned when it's a contract employees, is it like a fixed term employee? If it is fixed term employee, yes, they are.
Yeah. Is long service leave available pro rata after 7 years in certain circumstances?
It depends on the state, but the law says clearly how much it will be paid. So I can, it is not pro rata. It is based on the calculation available under the Long Service Leave Act. So we can give you, I can speak to you if you need to know more about that. We can talk about that more. Yeah.
Perfect. Thank you. Next question is, how does employment law apply if we hire international remote staff outside of Australia under our entity?
So for international employees, if they are your employee, you still need to provide superannuation contribution. That is required if they are like full-time employees or permanent part-time employees. Okay, so it depends on the actual employment, but normally you still have to pay superannuation to them, even though they are not working in Australia.
Perfect. Are you also able to clarify what sham contracting is?
Okay, sham contracting is more complicated. So it's about the misclassification of employees as independent contractors. You may know that independent contractors, they work for themselves. They are providing a service rather than working in the employer's service, and they usually they usually provide the service with their expertise and their experience for the exchange of a service fee, and and they also have their own equipment, and they are not generally not controlled by the employer on the day-to-day work. So if you are not if you are actually providing day-to-day supervision and controlling them on a day-to-day basis over their work, then there may be a misclassification between employee and independent contractor, and that was generally referred to as sham contracting. So it is a complicated issue. So if you want more information about that, you can either contact us or join our legal advice plan, then we can explain more to you in our consultation.
Thank you so much, Jess. All right, we've still got a few to get through, so we'll try to smash through these. So, whereabouts can we find the Fair Work information document that we need to provide to employees, or do we create the document from the information found on the Fair Work website?
Yeah, the Fair Work information statement and the casual employment information statement is available at the Fair Work website. So just do a Google search and you will find it.
Perfect. What criteria needs to be met in order for an employee to be entitled to leave for family/domestic violence?
So they need to. So the general idea is they need to be the person directly involved. Sorry, they need to be the person involved in the family and domestic violence instance, and they need to make the application, and they need to provide the relevant information about the instance in order to be able to enjoy the leave that they have to, and so it depends on the family and domestic instance that they are experiencing. So it is a case by case basis. Has to be evaluated on a case by case basis.
Perfect. Thank you. Now, this one here is a big one that we get a lot. How flexible do employees have to be in relation to work from home?
Well, working from home usually is available to employees who can do their work away from their office. So it depends on the job and the duties that the employees are performing. So if their job requires them to face the clients and do the job in a specific location, then usually work from home is not available. For example, if they are working in the shop, as a manager at the shop, then there's no way they can do the work from home. So it depends on the duties performed by the employee and the needs of the employer.
Brilliant. Okay, and we've got part-time employment contract still needs. Does a part-time employment contract still need an end date? What is the difference between fixed-term employment contract and a part-time one?
So part-time employment contract can be a part-time permanent contract, and it doesn't have to have an end date. So, but then you can include the termination clauses there in the part-time employment contract. So in the circumstances, for example, when the employee performs any serious misconduct, for example, then you can terminate their employment. And for fixed-term contracts, as I said, it's usually for the employee is usually hired for a particular term, for example, 1 year, or for a particular project. If the project is a 2-year project, then the employee will be hired on a 2-year term for that particular project. So it's different from the permanent employment contract. A permanent employment contract presumably assumes that the employment will be ongoing unless there is a termination event that happens.
Perfect, thank you. Just have one from Elizabeth here. Does the payslip have to break down the deductions like tax and HECS separately?
Yeah, the simple answer is yes, you do have to.
Perfect. And we've got how does employment law apply if we hire international? Oh, have I asked that one already? I don't believe so. How does employment law apply if we hire international remote staff outside of Australia under our entity?
When you say international law, so if an employee is hired by the employer in Australia, then certain employment law still applies to the employee. As I said, the employer may still need to provide the superannuation contribution to the employee, even though they are working remotely. And However, there may be some local law that the employer have to consider. For example, if an employee is working remotely in the Philippines, for example, then the Philippines law might apply to them. So my advice is to get a local lawyer to advise on the local law, and to see whether you can still hire them purely based on Australian law.
Perfect. Thank you, Jess. And last question from Suleen. Suleen's been amazing on the chat today. Thank you so much. How does employment law apply to contractors via Upwork?
So Upwork, I think they do have their own terms and conditions for working for them. And I believe it is an independent contractor arrangement. I'm not particularly familiar with Upwork, but I believe they are a independent contractor arrangement. So you provide the work as an independent contractor. You're responsible for your own work, and they are just a platform for you to interact with your client or with your principals. Yeah.
Beautiful. Thank you so much, Jess. That should be everything, guys. Thank you so much for the energy. Thank you everyone who's come by for the first time. Hopefully, we can continue to get you in. I will. Don't be surprised if you get a call from me later on. I do like to reach out and get a bit of feedback from everyone and learn a little bit about the businesses who are attending Lawpath's webinars to get an idea of just the changes of currents and see what kind of people are interested in looking at our services and also whether or not they're referred or not. So I will reach out. Thank you all so much for participating. Jess, thank you so much for your guidance and wisdom. If anyone's come late, I will go ahead and send an email shortly with the slides, our offers, the YouTube link, and all the other kind of information. Again, it's been an absolutely miserable day, guys, so hopefully we're able to brighten it up a little bit with some knowledge and guidance, and hopefully we've put your mind at ease with any kind of niggling issues at the back of your mind. But look, Lawpath are always available. 9 to 5:30 every day. We're always going to be here to answer any questions, offer our guidance, and support you where you need it. So if anyone is interested in just, I guess, taking that plunge and having to, invest in something that might protect you guys moving forward, then hopefully you can consider Lawpath. If you do, drop me your information. I'm happy to have a chat later on. Thank you all again. Have a lovely afternoon.
Thank you for having me. Thanks, Joe.